the Commission on Governmental Ethics and Election Practices. We're going to start right off with the minutes from the last meeting, the October 25th, 2023 meeting. Has everybody had a chance to review those?
I'll move we accept it as presented.
Okay,
I'll second.
it's been moved and seconded that we accept the minutes as presented. Actually, since we're all here, we can have a voice vote. Is there any discussion? Hearing none. All in favor, say aye.
Aye.
All opposed, say no. The minutes are approved. Moving on to agenda item 2, the public hearing on rulemaking. I'd like to open this public hearing on rulemaking with the rules that are in the materials. And this is the opportunity for anybody in the public who wishes to make a public statement to do so. There's also an opportunity to provide written comments if that's desired. Is there anybody here who would like to make a public comment on any of these rules? Please come up to the witness chair. Over here? Yes, great. And introduce yourself and tell us what rule that you're interested in.
Good morning, commissioners. My name is Will Hayward. I am here on behalf of Maine Citizens for Clean Elections. And I'm here just to briefly comment on the rules beginning on page 5. And this is about the determination of independent expenditures. And most of the rules today are routine and technical in nature and don't require comment from us. However, we would like to express our support for the language beginning on page 5 regarding the determination of an independent expenditure by shifting the language to focus on the effect of an expenditure, which is to influence elections, rather than trying to determine subjective intent behind an expenditure. The law now more effectively captures how money influences our elections, and so we're supportive of this.
Sure.
We have any questions?
Thank you very much. Does anybody have any questions for Mr. Hayward? Terrific. Thank you very much for your input.
Thank you.
Is there anyone else who'd like to provide comments on the proposed rules? And these are routine technical rules, so they will, at the end of the comment period, they'll be able to be put in place without further action from the legislature. So just wanted to make people aware of that. No one else? Okay, we'll close the public rulemaking session. Moving on to agenda item 3. This involves some potentially confidential information. And I'm going to read a script just so I don't follow anything up here. The next agenda item consists of 2 related potential enforcement matters: Alpine Initiatives LLC and Stop the Corridor, in which the commission previously directed staff to conduct investigations. Part of the commission's discussion of these matters may proceed in executive session when the discussion involves, quote, investigative working papers of the commission, unquote, which are made confidential under the provisions of Title 21A of the Maine Revised Statutes, Section 1003, Paragraph 3A. However, the law provides that the commission may disclose investigative working papers or discuss them at a public meeting if the information or record is relevant to a decision by the commission concerning an enforcement matter, unquote. Consequently, if called upon to make a decision in the matters relative to enforcement, the commission may well discuss its, quote, investigative working papers, unquote, openly in a public meeting with deliberations as provided by Title I of the Maine Revised Statutes, Section 402, Paragraph 2. Nevertheless, if the commission determines an executive session is necessary, it would only be called after a public recorded vote of 3/5 of the members present and voting, and would proceed in keeping with the provisions of Title I of the Maine Revised Statutes, Section 405, which allows executive sessions under specific circumstances. With that, I recognize the commission's executive director, Mr. Wayne, and the assigned assistant attorney general, Mr. Bolton, to address the 2 related matters. Thanks. Okay.
I think Jonathan's going to address you all on the substance, but just kind of a preliminary point that I wanted to make is that in terms of where we are right now, in terms of the investigative reports still being confidential, and I agree with the statement that you just read about your ability to make things public. I did want to point out that in the discussions that we've had with respondents, they have asserted that, among other things, they believe that the identity of the funder, the ultimate funder of these transactions that are at issue in the investigations is politically sensitive information. Their request is that the funder not be identified by name in this discussion, and that will be referred to as the client. And staff is supportive of that request for purposes of this discussion today. Obviously, it's your decision at the end of the day, but I just wanted to make you aware that we had those discussions, and we did agree that we would recommend to you that to proceed in that manner. The other thing I would just mention is I believe that the respondents have a view that certain other information is politically sensitive. I think they might want to address certain things if the discussion were to veer in those directions. I leave it to them to make those arguments to you if that in fact does come up. But I just wanted to sort of preface with that so you're all aware, because obviously once somebody identifies the funder or the client, then that can't be undone. So I wanted to say that at the outset.
Right, and I appreciate that. And I agree with that. I think at this stage of the proceedings that it's prudent to keep that information confidential. Who knows how things will progress and what we'll need to make public at a later date. But I think at this point, it makes a lot of sense to keep that information confidential. Mr. Wayne?
Sure. Well, just a quick background on where we are today. Commission authorized us to conduct 2 investigations into Stop the Corridor and Alpine Initiatives. And we received a large amount of documents and conducted interviews. And roughly a year ago, we suspended the investigation or request for information in order to write investigative reports in both matters. What followed from that was an invitation by the respondent to see if the commission would be interested in entering into consent agreements as an alternative to what the commission normally does, which is some sort of formal or informal adjudication. So staff entered into those negotiations, and our intention was to come up with 2 consent agreements that might be an appropriate way to settle this. But our intention was always that the commission would use its independent judgment to review those and make sure that you felt the outcome was right. The written presentation of the facts was as complete as you wanted it to be.
I don't think you have to worry about that.
Okay. Anyway, we were gratified that that's how you approached it as well.
Yeah.
So following your last meeting in October, Mr. Bolton circulated updated versions of the consent agreements that contain changes that the commission had requested. And I would say about half of those changes have been agreed to by the respondents. But one of the changes that respondents were uncomfortable with was the identification of the client in the agreement. And my understanding today is that they would like to make their pitch that it is unfair for the client to be identified in the body of the consent agreements. And I think that for that limited discussion, we're supportive of not naming the client. Okay, that's where we're at.
Great, thank you. Any questions from commission members for Mr. Wayne and Mr. Bolton?
Well, at the risk of doing there's no such question as stupid question poll. When you referenced an updated version of the consent agreement, I took some notes the last meeting for myself and still have that, but did we receive an actual new or edited version of that consent agreement?
You don't? I mean, you did not? I have paper copies available
Okay.
for you if you'd like to request them right now, and there's no procedural problem. We can provide you with those copies now.
I would like to see that.
Thank you for asking that.
Yeah, sure, let's do that.
That, John, do you have any comments on that?
Well, I was just saying that that's absolutely fine. I was, the only, I think, outstanding issue is, the identification of the client. I don't think there's issues, but you should obviously see the final language, otherwise agreed to.
Yep.
Thank you.
Is it marked up to show the changes?
Yes.
Great.
That'd be helpful. Thank you.
Certified copies for the commission. I'm assuming that I could respond enough.
Sure, unless do you have them already? I suspect it was.
We do have them, I just want to make sure that we see.
Sure.
Thank you.
It appears to be one of two. Right. Okay.
Yeah, no problem. No problem. Yeah.
Does anybody have any other questions for Mr. Wayne or Mr. Bolton at the moment? If not, I'll give the respondents a chance.
Can I just make one other clarification?
You certainly may.
Which I think you're all aware of, but just to, for the sake of completeness, that if these were entered into, the identity of the client would be disclosed in campaign finance filing that would be required by the consent agreement. There would be public disclosure.
Which last time was
Of the identity.
attached.
That's correct, and it would be attached. to the
And only
file.
one of them.
Correct, in one of them, that's right. So just to make that clear that this wouldn't be something that would be that would be not available to the public. It just would not be stated in the text of the consent.
But then again, only in one of them.
In one of them.
Which one?
The stop the corridor. That's that.
Any other questions right now from Mr. Wayne, Mr. Bolton? Okay, let's hear from respondents. I don't know how you'd like to organize this, but please introduce yourself and tell us to the extent that you can who you're representing, and we'd like to hear from you.
Thank you, Commissioner Schneider. My name is Paul McDonald of Bernstein Shore. I represent Clean Energy for Me LLC, which did business as Stop the Corridor. I'm going to speak on behalf of Stop the Corridor as well as the client. I think I'll be taking the lead on behalf of essentially our side of the issue here.
Okay, great.
So, I know you understand our position, I believe, but I don't want to take unnecessary time, so I'll try to summarize essentially. In this instance, as I agree with Mr. Bolton, that we're down to one issue, which is whether or not the client is identified in the consent agreement. We believe that the client should not be identified, because it's both unnecessary and unfair. Why is that? The client retained professional communications, public policy, political consultants to take action to oppose the NECEC corridor with the explicit instruction to take no action that would require the client's disclosure. Now, the client has a First Amendment right to engage in political speech and to remain anonymous. That's a subsidiary First Amendment right to engage in anonymous speech, so long as campaign finance laws do not require that disclosure. At all times, the client understood that all of the activities of the consultants were in accordance with the Maine campaign finance law and did not require the client's disclosure. In short, we believe that it's reasonable for you to conclude that the client acted entirely prudently. It hired local experts, directed them to comply with the law, and followed their advice. And in these circumstances, we believe that requiring the client to be identified in the consent agreement would be both unfair and unnecessary. Why is it unnecessary? As Commissioner Hastings has already observed, the identity of the client will be disclosed in one of the filings that accompanies one of the consent agreements. That disclosure is all of the disclosure that the public would have been entitled to receive had the disclosure been made in the 2019-2020 time period when the commission staff contends that the filings should have been made. Again, the public will get the disclosure. The staff contends it should have gotten back then. And for that reason, naming the client in the consent agreements is unnecessarily cumulative because its identity will already be revealed. It's also unfair to have the client's name revealed in the consent agreements because by doing so, it causes reputational harm. The client is not being accused of any unlawful activity in this proceeding and is facing no liability in the consent judgments. Having its name appear in the consent judgments casts some specter of guilt where none exists. It's an important consideration from the client's perspective. And the last point I would make is that we have spent a great deal of time with staff and their counsel working out the terms of these consent agreements. This process spanned many months and many meetings. All parties worked in good faith. It was a very productive exercise, and we believe we've come to a reasonable conclusion of that effort. The concession made by staff not to identify the client in the consent agreements was reached at an early stage of the negotiations. And following that, as the negotiations progressed, the respondents made concessions to reach agreement, but they were based on the fundamental point that the client was not going to be named in the consent agreements. So the process as it unfolded and resulted in these consent agreements that are before you was based on concessions that were made on the understanding that the client was not going to be named. Now, I can't undo history and know how the negotiations would have gone differently, but that was a fundamental point for us in terms of reaching other concessions. So I would say that we've had a reasonable expectation that the hard work that we all did would be respected by the commission and taken under serious consideration. I understand, as Mr. Lehman pointed out, that you have to exercise your independent judgment on all of this. But we would urge the commission to respect the work that counsel for the parties did over this period of time to reach this position. This is a fundamental point for us, and we are reluctantly agreeing to these consent agreements because this is a very complicated matter. If we were to go to hearing, there are a lot of contested issues. We have always thought that the best way to achieve finality and a reasonable result that we can live with was to enter into these consent agreements. We would urge you to accept them in the form that you have presented them to you at this point.
Thank you very much. And I can guarantee you that we definitely respect the hard work that both you and the members of staff have done in working these things out and in conducting the whole investigation as an entirety. So we respect that immensely. So thank you. Does anybody have any commission members have questions for Mr. Yes? Please.
Thank you, Mr. McDonald. I just wanted to make something crystal clear. You indicated that although not named in the body of the consent agreements, that the client is identified in one of the exhibits to the Clean Energy for Maine consent agreement. Is that correct?
That is correct.
And that the client and that identified a client is the same client that is referred to in the Alpine Initiatives
Yes.
LLC agreement.
Yes.
I want to make that very clear that is, the client is identified at least in
In the filing.
the exhibit B to the Clean Energy for Maine LLC proposed consent agreement.
That is correct, Commissioner Hastings.
Commissioner Newman.
Yeah, thank you, Mr. McDonald. I just want to ask you a little bit more about one of your, as I understand it, I don't mean to put words in your mouth, but I have sort of 4 reasons that you believe the client should remain anonymous. It's unnecessarily cumulative, causes reputational harm, is a fundamental point for the concessions that your client made. And I guess that kind of was really the 3 and 4 in my mind are similar. One of the things you mentioned in the beginning is that the client, you said, I think, took all efforts asking professionals to take all legal steps such that they could remain anonymous. So that's where I want to drill down a little bit. I'm wondering if you can remind me, if it's possible in this setting, what evidence there is that of that. And I'm concerned about sort of the slippery slope concept of future clients being able to sort of say, hey, do everything legal, and have someone else be the fall and never be named. That's the concern I have, and I'm wondering if you can address that.
Yeah, I guess, Commissioner Newman, the evidence in the record would be the testimony of the witnesses that was elicited by Commissioner staff and the council, as well as different documents. But I do not believe that it's a contested point, and from an evidentiary basis, that was the position that the client took. I would have to actually pull out the giant binder that you had and flip through the sheet. I think that it's in the record through the witnesses, and Mr. Montanelli may have a more precise evidentiary set than I would have.
I might add just two points. First is,
Could you introduce yourself, please?
I apologize, James Monteleone, also on behalf of Clean Energy for Me and this matter.
Thank
So, for one, there are, of the hundreds, thousands of pages of email conversations that are gathered, there's, in the South Dakota matter, there's not a single example of the client directing conduct that is identified as at issue in the consent agreement. In the Alpine matter, there's no communication whatsoever, no evidence whatsoever that the client even had knowledge that that action was being taken. And so for those reasons, there's sufficient disconnect between the client and consultants that were engaging in campaign activity, a strategy, that it's appropriate to preserve that separation as relates to the consent agreement.
And I think I'm getting your point, but could you both just speak to my slippery slope concern for lack of a better argument, which is to what is prevent future clients from, having to cover professionals and saying, well, if things go bad, we'll just take the fall and, I'll still be unnamed.
Well, I think if the commission accepts the consent agreements, they will be publicly available documents. Anybody who engages in this type of activity in the future will be cautioned by the terms of the consent agreements. Some of the statements in the consent agreements in terms of how the commission interprets definitions of expenditure, contribution, get out the vote, those types of activities, which from our client's perspective were viewed very differently in the past, okay? I think on a going forward basis, those people who are in the political consulting world and those wishing to engage in political speech will be cautioned by these consent agreements, because they make some significant pronouncements in terms of how the commission is viewing the activity that was under investigation here, which again, from our client's perspective, we firmly believed and believe to this day that everything that was done was lawful, consistent with the then extant statutes and regulations, and consistent with then extant guidance by the commission staff. The staff has changed its position on a number of these things, and that's information that's out in the world now for those to see. So I believe that the slippery slope is maybe not as slippery as you might think it will be, because I think these consent judgments will provide additional guidance to those who wish to engage in this form of political speech in the future.
Matt,
Sure, go ahead.
I just sort of want to turn to the commission, the other side of this agreement, and Mr. Bolton. I mean, do you agree with this? Is this part of the reason that you have agreed and forth to us an agreement that has the client identified only as the client? Is there anything else that you want to add about my concern?
I'll let Mr. Wayne speak as well. I mean, from my perspective, I think it was crucial to us, and this was a very highly negotiated aspect of the agreements, I think, where I think both sides were, spent some effort to try and get to something we could all live with. And I think from my perspective anyway, I think the fact that the client will be identified was crucial to us. And we feel like the agreements will accomplish that. And so that's why we were okay in the context of a, contested negotiation agreement to take the name out of the actual text of the agreement. It wasn't our initial position, obviously, but it's, we were able to, I think, come to terms with that, with the understanding, of course, that you all would make the final decision on what's acceptable.
And with respect to Mr. McDonald's comment that the disclosure statement attachment is what the public would have gotten anyway. Is that accurate? Do you see that as accurate?
The one thing I would say is that the consent agreement functions differently than a campaign finance report. The consent agreement is a description of what the violation was, and the consent agreement may contain additional details that are not just, the mere transaction details that appear in a campaign finance report. So there may be an argument for more detail to be included in a consent agreement than you would see in a campaign finance report. Mr. McDonald's points deserve very serious consideration. I think it is very relevant that we suspended the investigation where we were, and we don't have evidence yet, or as of now, that the client was aware of the Alpine Initiatives contribution. So I think there is a fairness argument there that has to be carefully considered. With respect to the corridor, I would say that client was an essential part of the transaction. The client funded the activity, the client is the reason for the activity. The staff's point of view, the client should have been disclosed 40 years ago. So I think the fairness argument is not as strong with respect to South Dakota. With respect to, obviously, I made an error in my comments and sorry.
Okay, Commissioner Marvel, do you have any question?
It's sort of a follow-up, and for full disclosure, my brain is not happy with the construction of the commentary and question I'm trying to deliver. This has been at times overwhelming to me, frankly, the amount of detail and information presented in this process. So I'm going to get to what I consider just a couple of simple baseline points, and it's probably going to come out more as a commentary than a question, but I encourage any of you to comment back if you wish. So as I understand it, the client is a significant company. And I read somewhere in the material, I cannot tell you the citation, at least one of the core reasons was that a DC line would not allow hookups through renewable projects. And that was really one of the core reasons for the opposition to this. And it was portrayed in a way that was at least neutral and perhaps even laudatory in some ways, because it was going to open up other competitive future business in the state. So my first question or comment is, if that's true, why simply not publicly engage in that and say, we're contesting this for this reason, sort of stuff? The second thing that I just keep puzzling about is why all of the carefully thought out initial effort to not disclose. You know, this is at times layers of separation 5 deep. It's thorough. It's longitudinal in terms of who gets to do what, cut off from what, that sort of structure. And again, I'm sorry if it's not crystal clear, but I think you know what I'm referring to. And then as an investigation started, there was significant resistance from not responding to contesting subpoenas to all of these kinds of things. And so at some level, I'm sitting here very uncomfortable with the very notion of acceding to most of this in an agreement which, to me, in some way, does not support our simple core mission, which is ensuring disclosure of relevant information and election matters to the public. And I really don't understand, I honestly don't understand all of from the get-go, all the way through, not disclose, not share, not identify. I don't understand it. Because to me, in terms of my lifespan in common business and interpersonal practice, that's usually an indication of some sense of guilt, of some sense of wrongdoing, of some sense of, I got to keep this quiet because I don't want it out there because it's not something I'd be proud of. So I warned you up front, that would be a little rambling and not really a question, but if you wish to comment, please do.
Commissioner Marvel, if I could respond to the 3 points that you raised. I think that the first two are quite similar. I mean, raising, understanding why not publicly engage and why go through the effort to not publicly engage. Now, at baseline, as Mr. McDonald said at the outset, the First Amendment protections that protect anonymous political speech are designed to support what are sometimes unfavorable, unpopular opinions that may draw backlash for one reason or another. Now, in that context, a challenge that we all have is that no one sitting at this table was engaged in the strategic decisions at that stage. We simply can't know. Candidly, I don't know what was going through the strategic processes at that moment in time. What was the basis of the concern at that moment in time? But at that moment in time, there was the good faith belief and the reliance on, you know, advice, the interpretation of local professionals about how this has played out in the past, based on commission guidance, and should play out in the future, would likely play out in the future. And in that regard, that reliance was what led, okay, we believe, our understanding is that this is entirely within the bounds of Maine law. And in that regard, it's appropriate. But beyond that, it's hard for us. We can't speculate as to why. Now, as to the third point you raised, characterizing STC's position along the way as being that of significant resistance. Again, I'd push back on that ever so slightly, because the concerns that were raised throughout the early stages of this investigation were not a matter of looking to avoid the investigation, but rather trying to understand the constitutional protections that apply to it. I mean, there were subpoena requests that we perceived to be very broad, that related to things that are entirely outside of the world of campaign activity, for example. And we addressed those issues with the commission, with commission members at that time, and expressed our concerns. The court heard our concerns, and when they were overruled, we complied. Comprehensive. So the efforts along the way to ensure that the scope of the investigation was within the bounds of what this commission initiated. I think it is unfair to characterize that as resistance as much as it was in trying to ensure that we were on the same page about what's under investigation.
Thank you for your response.
Commissioner Hastings?
Thank you. I'm a little concerned. I mean, the client certainly hired these both or retained. The other parties involved all were acting as agents for the client. No question about that in my mind. And it seems to me that principals are generally responsible for the conduct of their agents. And as Commissioner Newman has said, that should not be a way to shield yourself from violations of the Maine Clean Election Act. I do recognize that there is at least disclosure of the name of the client. Maybe I'm being overly picky, as long as the name of the client is disclosed. And Mr. McDonald has confirmed that the client is the same, that is the client in both of these consent agreements. For the record though, is it Monteleone?
Monteleone.
Well, excuse me. You had indicated that there was absolutely nothing to indicate that the client had really any knowledge of any of this. And that's not really my reading of the record, at least with respect to the Clean Energy for Maine action. There certainly was involvement of employees of the client. So I mean, that is an open question. It's not resolved here as far as I'm concerned. So there was some knowledge. At any rate, I still don't understand why the name can't be in there if it's in the exhibit, but I think you've made it clear that the client is identified and was the client in both of these. So I just don't hope the argument that you can hide behind the misconduct, if it will, or errors of the agents you have hired doesn't really fully answer this for me, and you're on your side.
Would you like to comment, Mr. McDonald?
Yeah, I'll try to respond to that, Commissioner Hastings. It seems to me that some of you are struggling, as I perceive perhaps commission staff were struggling with the policies behind our campaign finance disclosure laws. one of the primary policies being transparency, disclosure to the public. And we, for what it's worth, understand that policy, those policies, and we respect them. Believed that we respected them throughout this entire process, but the way I look at this is that you are trying to decide whether actual campaign finance laws as written were violated. And I don't think that it is appropriate to apply principal agency concepts in this instance, because it's the statutes themselves that determine liability. And the statutes as written and in force at the time of these activities did not impose liability on the client. So I understand too that you seem to be struggling, that it may be in your mind a distinction without a difference to not mention the client in the consent agreements, but to identify the client in the attachments. But it's a big difference to the client. It clearly believes that it will suffer reputational harm by having its name attached to a consent agreement. It's got stakeholders who will question this. It can impact a lot of operations, et cetera. So it is a very big deal to the client. We think it should be self-evident that if your name shows up in a consent agreement that imposes liability on somebody, that there's this specter that there may be some guilt associated there, and none has been found to it.
Commissioner,
I have a very specific question. I think I heard you just say that there's a difference between naming the client in the consent agreement versus an attachment to that consent agreement. Where my mind is going, if there's something attached, it's legally attached to a document, it's part of the document.
It's an exhibit to the document, and it's actually going to be filed on the commission's website. It's a campaign finance disclosure report, essentially.
Could I ask either Jonathan or Jonathan comment on that?
as in your role as a party to this matter, why don't you comment?
Well, I think actually, we talked about how this was a point that was, we negotiated quite a bit. And my recollection is that attaching the campaign finance report as an exhibit to the consent agreement was something that we asked for because of our concerns of making sure that this was going to be, apparent to the public who the client is. So that was actually, I believe that, I could be wrong about that, but my recollection from a couple months ago now is that was something that staff pushed for in order to make sure it wasn't just going to be a filing kind of off of the ether, but that it would actually be something you could see this agreement, you could flip to the attachment, and you could see the identity of the client.
Thank you.
Further, who was?
Briefly, I'm having difficulty finding it, in the clean energy, for Maine amended consent decree. Where does it say it's attached? What paragraph is it?
They're in the one that they just provided, we don't have the attachment.
But the attachment would be in the final version. It's just not
But
a copy, but yeah.
No, I
But which
understand that,
paragraph? Yeah.
which paragraph refers to it and incorporates it into the actual.
Just the one.
You would have in the original.
Yeah. Well, this is the amended consent decree. So
I think
not
he's
the
asking,
amended
is there a
consent
paragraph?
Is there a
that says-
paragraph that refers to the attachment?
Right.
It's paragraph 28, is that right? 28?
Paragraph 5, which is,
28 refers to it as well.
and paragraph 5 as well, that this rough language, which is the original language.
I see, the original language in paragraph 5, which. And that's the language that's still an issue.
So is there any language in the amended decree that references the exhibit B will be attached and incorporated into this document?
So I think the issue right now is that this, because we weren't able to reach agreement with the respondents on the underlying language, which is the actual identity of the client. The agreement that's sort of on the table right now would have the language that's currently struck out, if that makes sense. So that the material that's shaded, the few things that are shaded are things that we've been able to reach agreement on. And anything that's not shaded, that's in track changes, we weren't, and all those relate are the identity of the client.
So in paragraph 5, I mean, it's just difficult for me to understand.
Yeah.
The line that is actually struck out, the client, which is identified as stop the corridor's contributor and exhibit B
That,
remains in.
if you were to accept the consent agreement on the table right now, yes, that language would be in that agreement. So this is.
The stricken language is in the proposal that's on the table right now.
I don't know why I don't understand.
Yeah, so this is because this is the.
We may be
Most
this
recent
recent
draft that we proposed to
Work in
the
progress.
respondents. They accepted the changes that
Are
are
shaded.
that are
shaded,
shaded.
Okay.
and they did not accept the changes that are not shaded.
So the proposal on the table is this agreement with the shaded language and the crossed out
And the
language,
strikes.
That's exactly right.
not the other.
Thank you for clarifying that.
I just have a couple of questions.
Of course.
Just follow up.
Make sure we're clear.
Mr. McDonald, I appreciate your statement regarding the right of anonymity and its importance under the First Amendment, but there is agreement that the identity of the client should have been in that campaign finance report that is attached as Exhibit B, right?
Yes, if a campaign finance disclosure report was required to be filed, yes, the client would have been identified.
You're not conceding that it should have been?
Well, in the consent agreement,
You're saying.
we have reached a compromise there, but I just wanted to reiterate, we've always felt that they were not required, but we are compromising, and accepting that.
Okay, so this is a public hearing, so it's important that we ask questions that help the public understand the ultimate decision that we may make after considering what you've said and commission's recommendations and such. And in your argument, you make the claim that the client relied upon, in good faith, upon the advice of local people, local agencies, local companies, law firms, that not filing that report with their name on it was okay, basically, in simple terms, that report was not required.
That's correct.
And so my question is, and again, this is mostly because I want to have the public understand, because it's a complex issue, the reasonableness of the client's reliance upon who it relied upon to make the decision that report, their identity would not be disclosed within a report. And so was it one group of people? Was it one person? How many people did the client rely upon for that?
Essentially, two separate consultants.
And who would that be?
Okay, so it was my law firm, Bernstein, Shore, Sawyer, and Nelson, and Stop the Corridor,
Okay,
which was headed up by another very prominent, well-known, well-respected political consultant in the state of Maine. So, without sounding like I'm tooting our own horn, we believe that the client hired the best there was available in the state of Maine, and they felt that way too.
so Stop the Corridor provided that counsel or advice that that report was not need to be filed identifying the client.
Yes,
And Bernstein Shore did the same.
absolutely,
Okay.
yes.
Did Bernstein Shore provide only legal advice, or did it provide services other than legal advice? Because that's legal advice, am I
Yes.
correct? Okay,
Yes.
so did Bernstein Shore engage in any use of the funds from the client that were outside of the provision of just standard legal advice? Did it do lobbying, for example? Did it make contacts that would in any way be considered use of the funds for other than legal advice, such as campaign things?
Yes. I'll try to answer it this way, Commissioner Leclerc. The Stop the Core effort was multifaceted. All right, there was a lot that was done, and the vast majority of that effort is well outside the bounds of this investigation. This investigation with respect to Stop the Corridor has focused really on petitioning around an initiative that was put forth in 2019 and 2020 and was ultimately rendered moot by the law court's decision concerning the NECDC corridor. So yes, there was a lot of activity outside of this political realm that Bernstein Shore and Stop the Corridor were involved in. And I would also point out, not to get too far into the weeds, but most of the work that was done by my firm was done by people who are political consultants and not lawyers. So yes, there was legal advice provided, but there was also political consulting services that were provided, which are not necessarily legal services.
That, and those, and I understand that. I'm not saying there's anything wrong with that. But those political services were provided some from the funds that were provided by the client.
Yes.
And so my question to you, is it not more appropriate for the client or people in the future and your firm in the future to separate out the provision of legal advice separate from also benefiting? Like, yes, you can do this and we're going to get money, other money from it. I mean, there's a benefit that Bernstein Shore, from what you just said, acquired from having this money come in. Yes. And why is that not a conflict? How does that not separate? It's like, why isn't that a separate function? That would have, I mean, if an attorney was just advising the client as to whether this could actually be rewrite, which it wasn't, how is it not a compromise to have that same firm get profiting from political activity that it normally engages in?
Well, I frankly don't see that there's a conflict, Commissioner Leclerc. I believe that most, if not all of the major players, if you will, in the political realm within the state of Maine are law firms, work for law firms. We have our political consulting group, which provides non-legal services, but we are a full service law firm. So if we get engaged by a client in an engagement like this, and legal questions come up about whether or not certain activities that our political consultants are undertaking require disclosure under the campaign finance laws, we have lawyers who are expert in the field who provide the advice as to whether or not disclosure should be made or should not be made. And so we do not see that as a conflict at all.
Commissioner, may I add one distinction, is that the determination that happened in 2019, that there isn't a distinction between the legal services and other general consulting services, was in reliance on commission guidance that was in effect at the time. Now, since then, that guidance has been changed. And that's clear now. I think that the takeaway, the decision that was made at the time was in reliance on that guidance. Understanding through this process, through these consent agreements, and acknowledging that there, under current guidance, there would be a reporting obligation, demonstrates that there is that will be handled differently in the future.
Can you respond about the guidance changes?
First of all, I would say that the guidance that Mr. Monteleone is referring to has no bearing on the Alpine Initiatives investigation. I agree with Commissioner Leclerc that it would have been nice if outside counsel had been approached about this. And if you think about the nature of the Alpine Initiatives contribution, how it was structured, how work was undertaken, so that it was reported a particular way. The legal advice in that situation was not just, be careful, but the legal advice had a negative effect. And I just think that needs to be considered.
I mean, the concept of clients violating laws or ordinances or regulations based upon the advice of counsel is recognized in the law, but it's not a free ticket. And each case has to be analyzed according to the actual facts and underlying situations. And I appreciate and understand, I mean, that this is the way it's done, that there's many firms doing political and legal. I'm saying this maybe not a great idea and bears in the future some reconsideration of that, because to the average person walking down the street and asking us to do our job to assure transparency and full disclosure, we're saying this firm got so many thousands of dollars from this company with a direction, don't disclose our name, and also gave advice, oh, you don't need to disclose your name. Well, you benefited from that. The firm as a whole benefited from that. So to me, there may not be a conflict that will be cognizable in the legal profession or whatever. I'm not an expert on that, but in the public, I mean, I think clearly the client could have benefited from truly independent legal advice going forward. And I hope that is a standard that this commission will look to when somebody comes again, if they do, and saying, oh, we're not at fault because our lawyer told us to do it, when the lawyer was actually part of the profit thing.
Well,
And that's, my view from.
no, I appreciate those comments, Commissioner Leclerc, and I'll just respond in this way. These proceedings are a cautionary tale that we lived, but that others will be able to read after the fact, assuming we are able to come to an agreement, okay? A lot has been learned through this process in terms of how the commission staff will be viewing activities going forward. We certainly have learned some things that we didn't understand before. Mr. Wayne has indicated guidance has changed. These consent reports are making statements of the commission's position on certain legal issues that we thought were different in the past. I think people's conduct in the future will be guided by the outcome of these investigations. I would also say, just so that it isn't left unsaid, that our firm on a number of occasions gave advice not to take action. Because if you did, it would require disclosure, or if you didn't disclose, it would be a violation. So I didn't want the impression to be left that we were hired to essentially provide cover for activities that should otherwise have been reported. The record, I think, should be clear that we gave prudent legal advice and said, don't do certain things, and other things we said you are okay to do without reporting. So we believe we provided accurate, objective legal advice, regardless of the fact that we were engaged on a paying basis.
Well, perhaps it's an issue that the commission can consider in moving forward, and then perhaps look at adopting guidance or regulations advising the importance of obtaining truly independent legal advice, or even just calling the commission our staff is extremely, the staff of the commission is extremely knowledgeable. So I'll leave it at that. Thank you for your answers.
Mr. McDonald, Commissioner Leclerc's question brings to mind a question for me. Why is Bernstein Sure not conflicted out of negotiating this consent agreement? Aren't you independently interested in how Bernstein Sure is portrayed in the eventual consent agreement and the individuals who work for Bernstein Sure?
We represent Clean Energy for Maine.
Right.
In these proceedings. That is our client. We don't believe we had a conflict in representing them during the proceedings. We don't believe we have a conflict representing them now. Our undivided loyalty is to our client. We have pushed forward our client's interests vigorously throughout this, and
How can you separate out the interests of your firm?
we have been able, well, our firm is not. We've, I guess, what I can say is we have. We've had full consultation with all interested parties and have been able to move forward in agreement. And our client is fully engaged and on board with us continuing to represent it in these proceedings.
Have you brought the issue up to them, and have they specifically waived any conflict?
Yes.
Okay. Anybody else have any questions for the respondents or for our proponents? Rachel, Claire?
Okay.
Okay. Anything else you'd like to bring to our attention? Okay, anything else you guys would like to bring to our attention? Is there anybody else here who would like to speak on this matter? Should we go into an executive session to discuss the litigation strategy and the investigative reports a bit, or?
I think we should. I would like, is our attorney here?
He is.
I'm not quite a potted plant, but close. I'm here, and I should identify myself for the record. I'm Mark Terrison. I'm the contracted hearing officer who is present simply because there is a Maine Supreme Judicial Court decision called M.R.S. That deals with conflicts where an assistant attorney general is both investigator and prosecutor, while at the same time advising the commission. And the Supreme Court has determined in Maine that those roles should be separated. So if there is any ex parte communication, for example, in an executive session with Mr. Bolton being present as the Assistant Attorney General, any concerns about that under the M.R.S. decision, as I understand it, have been waived by the respondents.
I think they've been waiving them on a case-by-case basis. Is that
through
right?
this meeting, as I also understand it,
And
so
you
you
have
should
waived
make
it for this
clear
one.
on the record.
Yeah, I would appreciate it if you would confirm that you're still, the waiver is still.
The waiver is still in effect. We endorse Mr. Bolton speaking freely with you.
Terrific, thank you. And I want to make it clear,
That's through this meeting.
yes.
Yes.
And I want to make it clear that Mr. Terrison is here solely to represent the commission in this proceeding. And that Mr. Bolton is representing the staff's position in the adversarial proceeding. So, yeah, would someone like to, yeah,
Could I just add one, since if you had asked if anyone had.
yeah.
I'll do it from here.
You guys
I don't
can
wanna
vacate and,
I don't want to kick the other attorneys out, but.
Thank you.
you bet, thank you.
I'll be very brief. Newell Auger on behalf of Clean Energy Matters. I'm a lawyer with Pierce Atwood. We filed an initial complaint in this matter in January of 2020. I guess would want you to know that there is still a constituency out there that appreciates the work that you are doing and the work staff is doing. And I would simply echo the comments, especially the ones that Councilor Newman and Councilor Leclerc made about the importance of full disclosure in this matter. And we think that's a benefit to everyone in the state of Maine who was part of this discussion. I would also gently push back on comments that Councilor McDonald made. I don't have, obviously, and other than the five of you have privy to the commission's investigation. All we knew was back in January of 2020, when we had documents from some of the clerk's offices across the state of Maine when the signature gathering for the first referendum was taking place. And the documents we got back from the clerks, when you collect signatures to go get something on the ballot, the letters to the clerks had right up in the return and response envelope, "Stop the corridor," with an address. And having done some of these kinds of campaigns, I can tell you, if you're in for a dime, you're in for a dollar. And if anybody who was operating under the idea that Stop the Corridor was not involved in influencing a campaign to either get this on the ballot or have it discussed, that is a flagrant misnomer, misunderstanding. And you can't have your name on a document that's going to the clerk's office and then turn around and say that, well, we weren't really aware that there was an effort to influence a campaign in the state of Maine. That just doesn't make any sense at all. So I have no further information beyond that, but the three commissioners who initially voted for this investigation, I realize now, I think I'm, other than Executive Director Wayne, I think I'm the only person in the room who was in the room at that time. That, you know, they, I think Commissioner Nass and Commissioner Lee, and then subsequently Commissioner Lowy, who initially voted against the investigation in March, subsequently voted for it thereafter, because of just the initial bit of the onion that the commission staff was able to reveal. So I just leave that to your rumination as you continue to deliberate on this. And I think erring on the side of greater transparency and greater disclosure is always going to be the right decision.
Thank you.
I have one.
Yeah, please.
Can you comment on the impact, if any, of the timing of the report not being filed on time? And
well, I think Commissioner Leclerc, even when I filed this and our client filed it in January, we kind of knew that there was going to be a way for the opponents to make sure that nothing saw the light of day at the time of the election. And in fact, they were able to push it off well beyond that. And again, I would gently push back on Councilor Monteleone's comments that they were cooperative and participatory, because even after the commission voted in March of 2020 to begin the investigation, which I think everyone clearly in the room understood that the commission had done, the folks at Stop the Corridor made the argument that, well, actually the commission hadn't voted on it, and they don't have the authority to act on our complaint. They had to do it in their own right. So literally Commissioner Lee had to call an additional meeting in May to say in so many words, when we said we wanted to do investigation in March, we meant that we wanted to do an investigation. So they had to literally redo the vote just to clear the air. Then there was another court filing that Stop the Corridor made claiming that the request to do an investigation was somehow a final agency action, which it wasn't, and that was pretty clear. The Superior Court dismissed that summarily. But we had to go through the process of going to court, filing briefs and giving people extensions to file their briefs and then have a hearing. And that pushed it off yet another 6-7 months. And this is a repeated, this is the playbook to try to make sure that this information wasn't available to the Maine people at the time of the election. One other thing, I'm glad you asked it, and I don't mean to run on, but if you go through the confidentiality section of 1014 section 4, the documents that are meant to be, or that are given confidential protection tend to be financial documents. And then there's another provision which talks about strategic documents, political strategy, which I read as saying, if you're asking for information in the course of a campaign, and that information came to light, that would somehow affect the ability of the other side to prosecute a campaign fairly and properly. The campaign's over. It's been 2 years. This is just, sounds to me, and again, I've been as in the dark as anybody on this the last 2 years, but it sounds to me like this is kind of an embarrassment, or this would have, put egg on someone's face. The statute doesn't talk about that. The statute is talking about politically strategic information. Campaigns over. There's nothing, there's nothing strategic. As certainly as it relates to the campaign about the quarter.
Thank you. Any other questions,
Thank you very much.
commissioners? Thank you, Mr. Augur.
Thank you, Commissioner.
I have a thought. Can we postpone the executive session until near the end of the meeting and take care of our other business first? Because there's a bunch of folks
Sure.
here.
Absolutely.
I think that'll work out great.
Good idea.
All right, so let's move on for the time. We'll come back to this. But let's move on for the time being to agenda item 4. It's a late notice by Maine Energy Progress PAC to a major contributor. And the way we usually handle these is to Mr. Wayne will give us a briefing on the facts that the staff has uncovered, and then we'd like to hear from anybody who's here representing the respondent. So if there's is there anybody here on this issue? Great. If you come up to the witness table, that would be great. And is there anybody, I don't remember, is there anybody we have on Zoom for this? Okay, great. Well,
I think Emma Burke might be intended for the first.
Yeah,
Oh.
I'm on.
we see you, we hear you.
Hello.
Mr. Wayne.
Sure, I just want to give you some background on the next 4 agenda items. There's a law that has been in place since somewhere around 2018, 2019, that says if there is a contributor to a PAC or a ballot question committee that gives more than $100,000 to the PAC or the BQ to either support or oppose a ballot question, then the PAC or the BQC ballot question committee that receives the contribution is required to notify the contributor that the contributor has to file a campaign finance, a particular kind of report, financial report with our office. And in general, that's sort of unusual for campaign finance systems to actually ask the contributor to file a report. So this was sort of a step forward or step in a particular direction that the legislature took in 2018 and 2019. When, within a couple of years of the enactment of that law, there were some errors made and there were some penalty decisions by this commission about what would be the appropriate penalty. And there were 2 circumstances. Sometimes the PAC or the ballot question committee would be late in giving the notice to the contributor and also filing a copy with us. That's one type of violation that is before you today. Another type of violation is that the contributor was late in filing that special kind of report with us. So in 2020 and 2021, when the law was particularly new and there was a recognition that this might not be well understood, the commission staff started recommending penalties across the board of $2,500. And there were 5 outcomes in that range, in the amount of $2,500, both for late sending of notices and also late reports. With this background for these matters today, now that the law has been in effect for a longer time, and there's greater awareness, at least in Maine, about this requirement, at least among consultants and the lawyers who are involved. And because there's so much more money in these ballot question campaigns, the commission staff is inclined towards the view that instead of 2,500 being the precedent moving forward, that what we're inclined to do in terms of our recommendations is say that a baseline for our recommendations is going to be 5,000 for a violation, but that we might adjust upward or downward depending on the specific facts of the situation. You don't have to accept that. That's just our current thinking, and we will absolutely take our cue from your discussions here today. If that doesn't seem right, we'll change our direction. So I appreciate your patience with that. Maine Energy Progress is a ballot question committee that was formed to oppose 2 of the initiatives. It's a large ballot question committee. It raised more than $16 million. It hired professional staff. On October 24th, Maine Energy Progress, the ballot question committee, was required to send a notice to one of its contributors, Versant Power, that Versant was required to file a major contributor report. Unfortunately, the ballot question committee sent the notice to Versant 3 days late, and the preliminary penalty calculated at $25,768.87. The staff recommends reducing it to $3,000 to reflect that the ballot question committee acted responsibly once it noticed the error. It quickly arranged to have the notice sent to the contributor. That deserves some consideration. We also want to say that these notices are very important because a lot of times contributors don't know they have to file anything. So the function of the notice is that the PAC or the ballot question committee, which is regulated by our laws here and is more knowledgeable, will send it to the contributor. That is the trigger for the contributor to file the report. The notice was only 3 days late. And I'll stop right there because I know you want to go some about it. But from our point of view, $3,000 is an appropriate balancing of the factors in this matter. And that's the staff's recommendation.
I have a question. Did the late notice result in a late filing?
I think that Ms. Knox ought to address it. I think maybe it was the report might have been 1 day late. We should.
Yes, that's accurate.
Okay. Anybody else have?
Yeah, I have a question about, just with respect to the written report that staff created on page 4. Suggested penalty of 3,000, reduced from the base penalty of 5,000, yeah, et cetera. And recognizing this is a small percentage of its funds, the contributions from Versant representative. So can you just explain to me what, I'm not sure if I understand that, what is a small percentage of the contribution? The 3,000 or?
In general, I have to say that I want to invite Emma, who's on the phone call, to take a larger role, because she's aware of a lot of this factual nuts. There's a lot of my attention with on the previous matter. The only comment I would make is that this is a very large ballot question committee, but the contribution is quite large. The contribution is $257,000. So there are different ways to look at the scale of the situation.
And the penalty is 10% of the contribution.
Right.
And so I think what this paragraph is saying is that the $3,000 is a small percent of the 10%. Of there.
That's what I thought it meant, but I wanted to make sure that
I'm pretty sure that's what it.
a small percentage of the percentage.
Right.
Got it. Okay.
I think that's what.
Emma, does that sound right?
I think actually actually, what it was supposed to mean was that this ballot question committee raised and spent millions and millions of dollars. So as far as the funds from Versant represented overall a small percentage of the total funds the BQC received, accepted, and expended. So as far as them noticing and self-reporting the crossing of the $100,000 thresholds, which $100,000 is a low percentage of the amount of funds that they raised and spent, I think is actually what that sentence is supposed to represent, and just we didn't word it well.
No, yeah, I'm not trying to nitpick the sentence. I just wanted to make sure I was understanding, right? So you're saying that, if I'm understanding, 250,000 being over 100,000 compared to 15 million or something contribution.
Exactly.
For that, for this group, a low number.
Yeah, exactly.
Okay,
And I
thank
was
you.
also wrong.
We're all in good company. Thank you.
Any other questions for Mr. Wayne or?
Just for Emma, just briefly, so what day was the election, and is it Versant that we're talking about, their contribution? Did their report get in before the election?
I'm sorry, could you say that again?
Did the underlying report get filed before the election?
Yes, I think it was filed. Let me look.
What day later?
Yeah, so they sent the notice, they being Maine Energy Progress, sent the major contributor notice on October 27th, which was 3 days late. I received the report itself from Versant on October 28th, which was 1 day late because the reporting deadline was the 27th. But yes, that did come in before the election, and it was posted to our website before the election.
Thank you.
Yes.
Tracy.
I just want to point out that once before we had the argument that failure, the amount reported, although misreported or failed to report, dealing with the same election was filed several months, the report was filed several months after the election. And the argument made was that the amount, although it was large, was a small percentage of the total amount spent. And I think we just didn't take that. We looked at the size of the contribution more than the fact that it was a small percentage of the. I mean, I'm not saying I disagree in this case. It was a whole different back situation. That was contribution made prior to the election and not reported until several months after the election. So it's a different set of facts, but.
I agree, and I know we're not in discussion level. You know, one of the things I think we have to be really careful here is with these large amounts that these fines aren't just a cost of doing business. So it's
Exactly.
you know, the filing it's only a couple thousand, and yeah, there's no suggestion anyone did that intentionally. We want to mitigate that unintentional. Don't worry much about it.
So
And I think Commissioner McClare's question got to the heart of it, and it makes a difference, a big difference to me, whether the filing occurs before the election or not, because that's the key.
I have a little follow-up just to clarify. I'll blame it on the public's right to know, but I don't know. It's probably in here, but I don't know. Emma, so was this the only violation by this PAC?
Yes.
So they were dealing with a lot more money than this. And the mistake they made was involved with one of their smaller, you know, well, I can't call it a small donation, but a small contribution.
Correct. And yes, they had obviously the about $15 million moving in and out. And also just to clarify that the funds from Versant didn't come in one fell contribution of $100,000. It came in different amounts over time and aggregated to over $100,000. But other than that, I've had no issues with Energy Progress as far as late reports go.
Thank you.
Any other questions from commissioners, from Ms. Burke or Mr. Wayne? Ma'am, would you please introduce yourself? And we'd love to hear from you.
Good morning. Excuse me, lingering cold.
Sorry about that.
No, thank you, Commissioner Shire, members of the commission. My name is Kate Knox. I'm an attorney at Bernstein Sure, and I represent Maine Energy Progress. I hope, or I think, looking at your agenda today, that factually the situation you have before you is the simplest of the fact scenarios. And that is that mistakes happen, and this was a mistake. So we had a series of what we thought were pretty robust accounting protections. Watching, there was almost $16 million moving through these accounts. We were very fastidious, we thought, about tracking all the in-kind time from Versant, because that also accrues to your $100,000. And just in the course of the end of the campaign, doing a lot of other sort of, I was talking to Emma about this just for context, getting ready for that October report, getting all our vendors, who's making buys for us. You'll see on the reports, the expenditures are quite complicated. We're focused on that. We saw the draft of the October 27th report come through to the team, and we said, wait a minute, what is that? We immediately, I was in Arizona, within 5 hours, we had called Emma, said we made a mistake. The report is being filed immediately. We notified Versant. Quite frankly, Versant would have had their report in the same day, with the exception we needed someone in person to sign it, and we just needed 12 hours to get to that person in Bangor. So mistakes happen. We did the very best we could. I would like to say to the commission, I think as you're looking at these major contributor notices and the reports themselves, I would encourage you to think about the importance of self-reporting in this context. Your online system at this moment does not automatically flag major contributor mistakes. It does for other things, like 24-hour reports. If you do it incorrectly, you'll get a ding, right? You really rely on people for these major contributor reports to be good actors and to come forward and say, I made a mistake, here it is, or burdening the staff to go through everybody's reports and look through and aggregate. That's tough for them to do. So one of the things I would say to you is, I think it's important when you're thinking about cost of doing business, Commissioner Newman mentioned that, you want to make sure that you are rewarding people who come forward quickly, because it would be quite easy for somebody to say, I don't know if they'll notice it. I'm just going to hope nobody sees it, right? And we hope people don't do that, but certainly they could. So in this case, I think it's very important. We take pride in the fact that within 5 hours of finding it, we had notified you, sent the notice, sent it to the commission, sent it to the client, not the client, sorry, the contributor, and gotten it straightened out. And mistakes do happen. You'll hear that from people, despite your very best efforts to watch what's coming in and out, making sure you've got all your filings. You do occasionally make mistakes, and that's what happened here. So I'd be happy to answer any questions. I think Emma talked about the percentage of funds. Certainly $100,000 is not an insignificant contribution, but I think in the context of that 16 million, you know, that context and percentage is important. So I'm happy to answer any questions if I can, or provide any other context. It's helpful.
I'll just say that I agree with you on the importance of self-reporting, and for me individually as a commissioner, I think I take that into account when I'm deciding whether to waive a fine. So I laud your efforts to catch it.
It's not a great feeling.
No, I
will
know.
tell you, when you notice that mistake, and you have to pick up the phone and you sort of know what the cascade is going to account. But that is law, and obviously I and all my clients are, you know, we are that is the most important thing, that we're doing what we're supposed to do and sort of do our filings the way you require them to be done.
Thank you. Questions for Ms. Knox? Okay, thank you very
Thank
much.
you.
We appreciate it.
Appreciate it.
Would anybody like to make a motion?
I'll be happy to, move that the penalty be set at $3,000.
Is there a second?
Yeah. I'll second that.
Okay, it's been moved and seconded that the penalty is reduced to $3,000. Is there discussion?
Yeah, I am in support of that motion. I talked about the worry of this being the cost of business, how important it is. The reason that I in favor of the 3,000 is because it was self-reported very quickly, and it was ultimately disclosed before the election. So for those reasons, I think that this is appropriate.
I agree.
That's the one.
Okay, all in favor, please say aye.
Aye.
All opposed, please say no. The fine has been reduced to $3,000. Thank you. Agenda item 5. This is a late major contributor report from Genuine Auto Parts. Mr. Wayne, or is there anybody here representing Genuine Auto Parts?
So there was supposed to be Kathleen Idbo, who is the attorney, one of the head attorneys for Genuine Parts Company. She got confused about the timing of the meeting and was available on Zoom until a little while ago, but had to leave. So I do know her feelings about the staff recommendation, so I can fill you in on that after Jonathan gives his intro, if you would like.
Well, I think if they want to be heard, we should make it possible for them to be heard. Do we want to postpone this to the next meeting?
I don't see any harm in
Yeah.
doing so.
Well, why don't we hear what Emma has to say about, maybe they have.
Well,
maybe
okay.
Emma has some information that might
Yep.
change your mind on.
Yep.
Yeah, so she said that provided she agreed with the staff recommendation, and they would definitely, pay the staff recommendation if that's what you found today. However, she was concerned that if there were any, questions to be asked of her, or if it seemed that the commission was looking at a higher penalty, she would like to be involved with the process.
With that words.
Could we proceed, and if in fact we do decide we would want something higher, that we then continue this to bring up heard?
Well, I think we've got a couple of different opinions going on here. Let's take a vote. Would you like to make a motion?
I guess I'm just uncomfortable proceeding because she's not here. The person that's, the company that's subject to this does not have representation here, so just on that alone, I would say it's appropriate to postpone it.
Is there a
I
second?
second that much.
Okay. Is there any further discussion?
No.
Okay, we'll have a vote. The motion is to postpone this to the next meeting. All in favor, please say aye.
Aye.
All opposed, please say no.
No.
Okay. I believe the ayes have it. And we'll postpone this matter to the next meeting.
I will email her and let her know.
Terrific, thank you so much.
Of course.
Moving on to agenda item 6, late major contributor report from Dorman Products. Is there anybody here representing Dorman Products?
No, we have checked, sent multiple emails and have not heard any confirmation that anyone planned on attending.
Okay, Mr. Wayne.
Sure, can I just confirm that? Because the vice president and controller was on a list of expected Zoom participants, so I just want to know what we.
I sent an invitation, but it was not, he did not join us.
All right, thank you.
Okay.
And I follow up on that as well to ask him if he was attending, and he never responded.
Thank you.
I'll just give you the bare facts, and then Emma's available to provide more nuance if you'd like. In 2023 or earlier this year, Dorman Products contributed contributed $150,000 to promote the right to repair initiative. And so it was required to file a major contributor report with the commission by October 5th. Dorman Products filed a report 18 days late on October 23rd. So the preliminary penalty is calculated at $15,000, which is 10% of what Dorman Products contributed. And the staff is recommending a reduction to $5,000. And that reflects that the report was 18 days late and other factors.
Are there questions for Mr. Wayne?
I'm sorry, this is probably obvious. Who notice the error? With that? Did staff contact Dorman or did they self-report?
I'll have to turn to Emma on that one.
So this is tied up with the automotive right to repair. So they did receive their notice late. And I believe it was the work of automotive right to repair folks to Dorman to get their report in.
And who noticed the error? Like did staff notice the error or did you know?
Let me check the date. So I believe okay. Sorry, I do have COVID brain right now, so I'm just reminding myself of the okay, so yeah, so I received the report from Dorman on October 23rd. And that was an email I received from the treasurer of Automotive Right to Repair on the 23rd, that the email had attached the notice and the report. And so until the 23rd, I was not aware of this report being necessary.
Thank you.
Commissioner Hastings, did you have a question?
We're focusing on Dorman at this time, not on the failure of M.R.S. to file this initial notice, correct, which was quite late. Correct. And these dates get me. I'm trying to figure them out. So Dorman got its notice on August 27th. And at that time, that starts a new time to get their contributor report in. They have until what, the next major, what's the deadline? Once, if Dorman received it late, does that changed the deadline for them to file their own report, doesn't it?
That's essentially how I treated it, yes, because it, just doesn't seem remotely fair to require someone to file a report before they've received a notice that they have a report to file.
Well, you gave them until
October 5th.
August 27th, and you didn't consider them late until about 6 weeks later on October 5th.
Correct.
And they never did file it until another almost 3 weeks later, October 23rd.
Correct.
I think it's the timeline, isn't it?
Yeah.
What is the normal, once a major contributor gets a notice, how long do they have to file their report?
So there's not, they have until the next normal reporting deadline. So depending on when their contributions exceed $100,000, and then the notice has to be sent within 5 days, it could really be a length of time of a couple of months or a few days.
This was a single $150,000 contribution, so it met that limit immediately.
Correct.
So
Could be a couple days. Bad week.
Could be, but in this case, it was about 5-6 weeks.
Yeah.
Well, even,
The other thing is looking at the letter they submitted. I don't sense a lot of accountability. Frankly, it's basically, if you're gonna give $150,000 to a campaign or a referendum question, you should have some sense that some requirement for reporting that may exist. Like, I would just look for more communication on their part, than saying, we didn't know, we don't do this. It's not like they dropped $5 to qualify, to a clean election campaign.
Can I ask another question?
Please, please.
Emma, so what, the notice that went to Dorman late, admittedly late. Could you tell us basically what that notice told them?
Yeah,
I mean,
so
the
that,
timing goes,
yeah, so the notice has a schedule on it and says basically if you donated between these dates, this is when it must be filed. And it gives, the date ranges and then the deadlines. So that's the notice that they were sent on August 27th.
and, so looking at that notice, again, when was their report supposed to be filed? This is given the amount of their contribution and the date of their contribution, the date of the notice they received.
That would have been October 5th.
October 5th. Thank you.
Commissioner Hastings. Emma, would, Mater have reported the Dorman contribution on its own July quarterly report?
Yes.
Any other questions from commissioners? Would anybody like to make a motion? Hearing none, I'll make a motion that we reduce the penalty of $150,000, or yes, that we reduce the penalty of $15,000 to $5,000. Is there discussion of that?
Well, I'll say it, if 5,000 is base, I mean, they're significantly over their October 5th deadline. And so I have to admit a little bit of uncomfortability.
If you'd like to make a motion to amend, I received that happily.
I mean, something to express that the commission is somewhat, concerned about that.
It is more than the average
And
violation.
I do say this understanding that this is not a company that forays into, according to the report, is not they don't make a lot of political contributions, so, that mitigates certainly, but I would probably suggest to just say that we have some concerns, amended to 6,000.
Okay. Is there a second for that? Hearing none, that motion fails for lack of a second. So we still have the motion for, to impose a penalty or to reduce the penalty to $5,000.
I'll say the reason I'm in support of the $5,000 penalty at the staff recommendation is I took what they said in their comments about how previously when the law was first changed, it was 2,500. Now some time has passed. It's appropriate to increase those penalties. So we don't have the cost of doing business to send a message. I do think that this was, late. They had some time. It wasn't like the last one we discussed, but this is although it's a lot of money, it's a new, participant in elections. And so I think that $5,000 is an appropriate penalty for that person and, warning to future contributors. And again, I also note that it was ultimately reported before the election and had been reported by Martyr. So I'm in favor of the $5,000.
I agree. Any other comments?
No.
Questions? All right, hearing none, we'll have a vote. All in favor of reducing the penalty to $5,000, please say aye.
Aye.
All opposed, please say no. Penalty is reduced to $5,000. Moving on to agenda item 7. This is the late notices to major contributors by the Maine Automotive Right to Repair Committee. Is there anybody here representing them? Please come to the witness table.
Thank you very much.
And we'll hear from Mr. Wayne, and then you guys can address us.
Sure. Maine Automotive Right to Repair was a ballot committee that was set up to promote the Right to Repair initiative. And between May and September, the ballot committee received contributions greater than $100,000 from 6 contributors. So between May 10th and September 6th, the committee was required to send notices to the major contributors and also to send those notices to the commission. The ballot question committee was late in sending 5 of those notices to contributors and was late in filing copies with us of all 6 of the notices. The preliminary penalties for sending the notices late add up to $240,000. Staff is recommending a reduction to $55,000. And I did want to acknowledge, I think the chart on the last page of the staff memo may contain a numerical error. It indicates that we're recommending 50,000 as a penalty. We're actually recommending 55,000. If I'm wrong on that, Emma, can you correct?
55?
Yes, 50.
Yes, that's correct.
Well, the numbers in the last column add up to 50. So where would that extra $5,000 be?
Our proposed penalty for sending the notice late to Clarios is listed as 5,000. The staff recommendation is actually that be 10,000.
Okay. Okay. Ms. Burke, would you like to address this at all?
Yeah, so just, to run through what occurred. So, on October 5th, I received an email from Maine Automotive Right to Repair's treasurer, Jennifer Bonarigo, that had 5 notices and 4 reports at that time. At that time, all of those notices were well past the 5 days due for us. And the 4 reports were filed on time. There was one report that was genuine's, that was filed 1 day late on October 6th. And then later on October 23rd, Jennifer sent me another email with a notice and report attached, and those were from Dorman. And again, the notices were well past the 5 days they were required to be sent to us by. So that is what essentially kicked off this penalty occurrence for them. I am aware that they in last December filed their first major contributor report with us. And at that time, as I was discussing with the ballot question committee, how to file major contributor reports, the subject of the notice did not come up because the dates I had at that time were that the report was filed. The report itself, the major contributor report itself, was filed within the 5 days of the $100,000 contribution happening. So I did not go into the notice aspect of it because the report was already filed. The report was already done within that 5-day window. So at that time, I did not discuss with them the need for them to send notices. It was also clear that they were aware of the major contributor reporting requirement, and part of that requirement is to send notices, which is included in all of our guidance and on all forms. So on October 5th, I communicated to them. I immediately responded to Jennifer via email that day and said, this is, that these notices are late. There will be a penalty for this. And got them posted, got the reports posted to our website. And I posted the report to the website on October 23rd as well when I received the report for Dorman.
Okay, thank you. Commissioners have questions for Ms. Burke or Mr. Wayne? Okay, sure. Would you like to introduce yourselves and address the commission?
Thank you so much. Good morning. I'm Adrienne Fouts. I'm an attorney with Drummond Woodson, and I represent the Maine Automotive Right to Repair Committee.
Fouts, F-A-U?
Fouts, F-O-U-T-S.
I was not even close.
No problem. I'm here with Jennifer Bonarigo, who is the treasurer for the committee. Also with us is my colleague, Mark Gallagher, who is a political consultant with Drummond Woodson. I just first wanted to sort of clarify the roles between Mr. Gallagher and Ms. Bonarigo as it relates to the committee, because there are some references to those roles in the memo from commission staff. Ms. Bonarigo is the treasurer. She was in charge of compliance, and Mr. Gallagher, although he has experience in that area as well, for this particular committee, his role was campaign focused strategy. So his role was not compliance in this particular instance. Just wanted to clarify that piece. We very much appreciate the opportunity to be here and to speak with you about this issue. We think it's seriously. I'd like to cover sort of 3 main points that we'd like to emphasize, and of course, we're happy to answer any questions. The first thing to emphasize is that the committee takes responsibility for these errors. It acknowledges that errors were made with respect to the major contributor notices, and that those errors are the responsibility of the committee. In our letter requesting the waiver, we did try to sort of explain what contributed to the misunderstanding, but ultimately understanding what the requirements are and complying with those requirements, we fully acknowledged lies with the committee itself.
Thank you for that.
Thank you. And second, I don't believe there's any question about this, but I also wanted to just make crystal clear that this is a situation of mistake. There was no intent to hide any information or, any benefit to doing so. This is an error that, is now causing a problem for this committee. It was not something that was intentional. This was Ms. Bonarigo's first time working on a Maine-based initiative. She was, unaware of the requirements, endeavored to become familiar with them and comply with them, but did ultimately make some mistakes. I think that, and I know the dates, and looking at the charts with the dates can get somewhat confusing, so we can go through it in as much detail as you like. But I think when you look at the dates that notices were sent by the committee to contributors and the dates that the notices were sent to the commission by the committee, you can see from those dates sort of on the face that this is a case of mistake. I believe actually this is one factual distinction with what the commission staff has stated. I believe there were 2 notices sent timely to contributors, and I think that's advance and genuine, actually, I believe. Excuse me. And so 2 of the 6 were timely sent to notices were timely sent to the contributors themselves. And then all 6 notices were late going to the commission. 5 of those 6 were sent on October 5th, which was the date that the quarterly report was due from the committee, which was the date that Ms. Bonarigo mistakenly believed was the deadline. So when you look at those dates, I think on the face, you can see this was a case of misunderstanding what the requirements were. There's one outlier here, which is Dorman Products. That was a case of inadvertence. It simply got lost in the shuffle. And sort of moving on to the third point, I wanted to make, which is that the committee, although it did make mistakes, did endeavor in good faith to comply with these requirements. I think the commission staff has acknowledged in its memo that it had multiple conversations and correspondences with Ms. Bonarigo as she endeavored to try to understand and meet these requirements. Ms. Bonarigo misunderstood what the requirements were and was not aware that mistakes had been made until she received notice, as Ms. Burke described, on October 5th, immediately following submitting the reports to the commission. Emma reached back out and said, you know, some of these notices weren't timely done. And that was the first that Ms. Bonarigo understood that she had made mistakes. She then looked into the notices that she had made for major contributors and realized there was an additional error that the commission was unaware of with respect to dormant products, remedied that as soon as possible and notified the commission. So, you know, there were good faith efforts here, although we fully acknowledge that mistakes were made. The commission has already sort of looked at this issue with respect to prior agenda items, and that is, you know, kind of what was the ultimate impact of this. All of the, well, all of the quarterly reporting that's required correctly and timely included these major contributions. That information was timely and correctly available to the public. 4 of the 6 major contributor reports, which of course ultimately is the obligation of the contributor, were timely provided. And really only one late notice by the committee was late enough to a contributor to cause a late major contributor report being filed with the commission. So ultimately, the information available to the public that would, you know, inform them about who's contributing to this ballot question was timely available in the public reporting, with the exception of 2 major contributor reports. Those are genuine and dormant. I understand that this is a separate obligation, that the major contributor reports serve a purpose, and that's a separate obligation than the, you know, quarterly and special reporting. I do think, given that this is a fairly new requirement and not as often implicated based on levels of funding, that the public and the press are accustomed, historically at least, to looking to the quarterly and the special financial reports that are filed to find this information. And those were timely provided with the correct major contributor information. So, you know, this is not a case of attempting to hide anything from the public. This is a case of a misunderstanding that contributed really to 5 of the 6 issues. And with respect to the 6th, dormant products, a case of inadvertence and mistake that was not discovered until the commission had reached out to Ms. Bonarigo, and she looked into this and then self-reported. I'm happy to stop there, and I know that's a lot, and I know there are a lot of dates in the mix. If you have any questions at all for us, we're happy to answer them. So I'll pause there for now.
Well, thank you very much for your comments. Do commissioners have any questions?
I'm just gonna ask a question. The major contributor reports, did any of them end up getting filed by the major contributors after the election?
No, they were all filed by the election. The latest, I believe, was dormant, but still within 3 weeks, I believe, before the election.
Thank you.
Any other questions from commissioners? Okay, great. Thank you very much. Is there anybody else here who'd like to speak on this?
Excuse me, Chairman, I'm sorry, could I add a couple more?
Of course, of course.
I wanted to make sure there weren't any questions from the commissioners about that lengthy recitation I just gave, but I was hoping to speak to just 2 other things
Please
quickly.
do, please do.
Completely, you know, respecting and understanding the discretion of the commission as it relates to deciding what the proper penalty is. And we appreciate the commission staff's recommendation of a substantially reduced penalty from the otherwise statutory penalty. I do I would encourage the commission to consider a penalty of $5,000 per violation, with the exception of the dormant products, which is a lengthier violation and, lengthier delay, and was caused by mistaken inadvertence. We would ask that you would consider a penalty of a total of $35,000, which would be 5,000 times 5 for 5 violations plus 10 for dormant products. Given that this was an instance of someone new to these rules endeavoring to comply that made, honest mistakes, and also in one case, sort of an administrative oversight and inadvertence. So respectfully submit those comments, understanding and appreciating your discretion. There was also, and I don't want to preempt it, but there was a letter submitted on this topic by an outside sort of third party who I understand will likely want to speak to this matter. I know that's within the commission's discretion to allow that. I would suggest that that's sort of appears on its face to be purely politically motivated, and it's not something the commission should engage with. If you are inclined to hear from, I believe it's Mr. Auger, I would ask just to have a chance to respond to his comments.
Terrific, thank you for your
Thank you.
comment. Any other questions now from commissioners? Yes,
I have
Commissioner.
one specific one. In the memo we've received, on page 3, it says Martyr has requested a reduction of total penalties to 15,000.
True.
You're offering an increase over that this morning. Is that correct?
Yes, sir. So this was based on sort of what's been described as the prior baseline penalty of 2,500 per violation, which times the 6 would be
Okay.
the 15. But I understand the sort of policy purposes behind increasing that baseline to 5, and believe that that would be appropriate for 5 of the 6 violations. Understanding the dormant products violations
I get the
is slightly
rationale
more
now. Thank you.
egregious. Yeah. Thank you.
And I have
Commissioner?
a clarifying question, which I don't think needs clarifying, but I'm gonna do it. I'll blame it on wanting the public to be that they understand. I like.
You're gonna use it?
Commissioner, aside from Norman, which I think you've explained was an inadvertent, as you described it as an inadvertent outlier, the other major contributors, everybody was not notified at the same time and then notified at the same time. Is that correct based on I'm trying to pronounce right, Martyr's activity? In other words, the staff, and Emma, you can jump in here too, has suggested different penalties, which of course we're about to determine based on the notice, but that's based on when those contributors met the deadline, which is going to vary. But from respect to your clients' activities, they all were supposed to have been sent notices by a certain date and missed that date, and then were all sent notices at the same time. Do I have that right, or was there different activity on your client's part?
I think, and I'm happy to have Ms. Bonarigo respond in particular if this doesn't answer it, but I believe, so on page 2 of the memo, I think that sets out when the notices were due versus when they're actually sent, in that chart there. So
I was looking at the chart, so I think
yeah, no, I've done the same. So that August 17th, 2023 date is when the majority, and then there's one on August 16th, the majority of the notices were sent by the committee, which was not necessarily the date that they should have been sent. Basically, the 5 days running from the time that the total contribution met the $100,000, threshold. So that would have been triggered on different dates, which is, also a column there, the third column. So based on Ms. Bonarigo's understanding that the only applicable deadline was that the major contributor report itself be filed with the commission by the quarterly reporting deadline. I think that's what triggered, sort of aggregating them at a time that felt reasonable with enough advance notice to have them comply with that quarterly reporting deadline to send in their major contributor report. Is there anything you want to add to that? Okay.
And that clarifies for me. Thank you.
Okay, you're welcome.
Other questions from the commission? Okay, thank you very much.
Thank you so much.
Appreciate it.
Thank you.
Could
Is
I
there anybody
offer a
else
point of oh, sorry, Chair.
No, of course,
Delay. I just wanted to offer a point of clarification, if you don't mind.
I don't mind.
So there was some confusion initially about the timing of Genuine's notice. So Ms. Fouts had said that essentially there were only 4 notices sent to contributors late and not 5, but that is not accurate. So the notice to Genuine was dated September 1st, but according to an email I received from Ms. Bonarigo, it was actually sent September 27th, which is the date that I use here. So I just wanted to clarify that even though the notice was dated September 1st, that Ms. Bonarigo followed up with an email to me saying it was actually sent the 27th. So my table with the dates is both tables are accurate as far as dates and notices sent.
Great, thank you for clarifying that. I was going to ask Ms. Fouts.
Okay,
Yes, I will speak to that.
Great.
So in this case, I had sent an email, the notice via email to my contact, my billing contact. He was in the process of retiring, so he wasn't always checking his emails. And then when we learned that we had done things incorrectly, I reached back out to them and we made sure that we got them on the phone, and they actually were able to get us the information within that day, within 1 business day. Once clarified that with them.
So you notify them the 1st and the 27th, is that?
There was an email sent in August with the rest of them, and that email was not seen by the person that I had sent it to. And then on the 27th, as we're collecting everything, getting ready for the Q3 reporting, that's when I noticed that we hadn't received it, and then I reached out to them, and at that point, they were able to get back to us, although not in time for the report, but then the report came in the next day. The report was due on the October 5th. We got in touch with them on the 6th, and they got back to us on the 6th, and we sent the report in on the 6th.
Great, thank you.
Thank you very much.
Any other questions from commissioners? Great, thank you.
Thank you.
Is there anybody else who'd like to address us?
Yes, please.
Mr. Auger? And I'll tell you, Mr. Auger, I tend to agree with the respondents that it's not really appropriate for you to do this as a representative of their opponent. I think I will welcome your comments as a member of the public. But it's at least unseemly and perhaps improper for you to be representing their opponent to suggest that the fine shouldn't be waived.
May I offer a bit of history as I start? Newell Auger with Pierce Applewood on behalf of automakers and repairs for vehicle repair choice.
So you're insisting on being here on behalf of the.
If I may, I represented in the Clean Energy Matters bit, if you remember, there was a decision by the commission to require our PAC to file a second major donor report. And there was a genuine confusion because it was essentially the same issue and the same but a new referendum question. And the commission's decision was that we would have to file a second major donor report. It was my mistake. We owned up to that and paid that fine. Adam Cody from Ms. Fouts' law firm came here after that presentation and suggested and was given the opportunity to speak to insist that the penalty be increased. So I'm not here to insist that the penalty be increased. I'm simply suggesting to the commission that it not be lowered any further than what the commission has proposed. And if with your indulgences, I just make 2 points to that effect, if that's okay.
Go ahead.
The first is that this would mark, I believe, the greatest act of clemency by this commission in the 17 years I've been appearing before this board. It's basically a forgiveness of $185,000. And in doing so, sort of, we think about the recipient of that quarter. As a level set, when the major contributor law was passed in 2018, it was passed with unanimous support of the legislature. The law itself, 1865, and I was in the committee hearings for some of those discussions. There was some disagreement about the issue of signature collection and how that got registered with the commission or with the Secretary of State. But on the issue of the major contributor and the requirement to file, there was unanimous support for that. And the reason is that we, unfortunately, to Executive Director Green's point, are a cheap date. The number of signatures that you need to get onto the ballot in Maine is very low, 67,000 signatures and change. It does not take that much money to run an effective political campaign. And increasingly, I think we've seen a proliferation of business interests, business initiatives being presented to the Maine people, not citizens initiatives. Now, the legislature wasn't about to scuttle that whole statute. It's obviously part of the Constitution. It's part of our ethic. And frankly, if they did, many of us in the room would probably be out of a job. So, but in all seriousness, I think the reason for putting these guardrails on the proliferation of these types of business initiatives is so Maine people will know where the money is coming from, especially when increasingly the money is not, and the organizational effort is not coming from within the state of Maine, but from outside. I do not dispute that Ms. Bonarigo made an honest mistake. I don't dispute that they got great legal advice, but that mistake did not inure to the benefit of Maine voters, because the major donor report was filed later. And in fact, I just discovered it here. The Dorman product notice was due in May, which means they received the notice in August, but their major donor report, by my recollection, if you're looking at the proper filing dates, should have been filed in June or July 17th. They only filed it later because that's when they got the notice from the political committee that was prosecuting this election. And so again, the availability of the information, the major donor report, it gives more information to Maine people beyond simply just the campaign finance notice saying that so-and-so gave so much money on such and such a date. It's considerably more specific in terms of who that actor is that is trying to influence an election in this state. And for those reasons, I think that the penalty is suggested by the commission staff should not be further adjusted. If anything, it should be higher. I'll leave it at that. I appreciate your indulgences allowing me to speak.
Are there questions from commissioners? Commissioner Hastings.
Ms. Clark, I kind of share your lament about the petition process having been turned into business initiatives in many cases. I do have to note, though, you appear to be appearing for one of those business interests yourself.
I don't dispute that, Commissioner. I don't dispute that, although I would say that I think it's a little different when it's an entity that's responding to a proposal than an entity that is actively trying to push an agenda. I think that's the point the differentiation I would make is that a business interest that, can't do anything in DC or can't do anything, doesn't have the support of the legislature, then manages to craft a piece of legislation and get it onto the ballot. And I think there's a affirmative, or there's an action there that I think is more worthy of of careful introspection than simply an entity that's responding to such an
Thank you.
initiative.
Any other questions from commissioners?
I don't have any questions. I do want to just comment, you know, the public nature of the hearings, why, and I hate to sort of talk about, we just open the gate and let all the chickens out and why it's okay to, for the chickens to be out. But I do think that we generally have a practice of hearing from the public and including opposing parties, you know, political campaigns. And so I just want to say that's why I thought it was appropriate that we let Mr. Auger
I would
speak.
agree. I think it's appropriate.
Yeah, and we certainly take everybody's, I guess, positions and backgrounds, you know, that's part of our assessment as we're.
Sure. Very good. Any other questions? Okay, great. Thank you.
Thank you, Commissioner Stein.
Ms. Phelps, would you like to reply?
Yes, thank you. Just briefly.
Sure.
Appreciating that there is value in sort of allowing public comment. I acknowledge that, but I do think, the sort of politicized nature of the comments from Mr. Auger are counter to the purpose of this meeting and this agenda item. I think some of the commissioners picked up on some of the ironies in the comments based on the fact that Mr. Auger is representing the main opponent to question 4 and the opposing ballot question committee. I'll just make a couple points on that. One, it is very much a business interest to defend automakers in maintaining this monopoly that they had created for themselves as it relates to this repair issue. That's why this initiative came to Maine. That's why there was a defense, you know, against an opposition against this initiative. It was very much business motivated on both sides. It's, I would say, the suggestion that this was an unwelcome question is irrelevant to this particular question about penalties for the mistakes made by the committee. Talking about this being an outside business motivated initiative is ironic for the reasons I mentioned, but also because, you know, the opposing BQC that Mr. Auger represents is also a national effort. Its primary lobbyist in this matter that came to Maine was from Virginia. Its primary contributor was from Washington, D.C. I mean, this is not, those criticisms can be, you know, lobbed directly back at him and the committee that he represents. And I really think they're irrelevant to the question about penalties. On the actual relevant question of what information was available to the public when, the example that Mr. Auger points to related to Dorman products, that, as I said, that contribution was included on the July 17th, 2023 quarterly report filed by the committee, and that information was available to the public many months in advance of the election. So that's all I'd like to say, unless you have other questions for me.
Thank you. Anybody have any other questions?
Thank you so
Okay,
much.
thank you very much. All right, would anybody like to make a motion?
I would move that we support the commission staff recommendation of a penalty of $55,000.
Is there a second for that?
I'll second that.
Okay. Discussion?
Make a motion to modify, is that what it is? Amend,
To amend,
amend,
yep,
amend.
yep.
And I would take the lead of the chair and listen to that.
Thanks, and I am going to make a motion to amend to the $35,000. That is what I had been planning to suggest. I will just say before the council suggested that amount for the same reasons, 5,000 for each activity aside from dormant and 10,000 for dormant. The reason for that is that it seems to me the penalty.
Can I second that?
Oh, I'm sorry, thanks.
I'll second that.
So now I'll just tell you my reasoning is that it's this is multiple different agencies, one treasurer. And I really do see it as one mistake. Again, dormant being the outlier, which is why there should be an increased penalty for that. And of course, we just discussed dormant, is also going to be paying a penalty on that. Increasing the other amounts by the days, it doesn't seem to have a purpose here. It was one mistake that the dates were gonna be what the dates were gonna be because of the confusion with the reporting requirements. A $35,000 fine, and a $5,000 fine penalty for each individual account, I think serves all the purposes we discussed previously. Also, aside from the dormant being 10,000, we previously upheld penalties for 5,000 in cases where it was before the election and it was properly documented in the other reports, which is the case with all of these as well. So that's why I'm making my motion for 35,000.
And I agree. I think that the 5 of the 6 fall squarely into the kind of ordinary category with just being mistakes. I think the one that falls outside of that category is the dormant contribution, and I think increasing the fine to $10,000 for that is entirely appropriate. So I support the $35,000 the waiver to 35,000. Any other discussion? Hearing none, we'll have let's vote on the amendment. This is the amendment to reduce the fine to $35,000. All in favor, please say aye.
Aye.
All opposed, please say no. That motion passes. So we're now looking at a motion to waive all but $35,000 of the fine. That's been moved and seconded. Is there further discussion about that? Okay, we'll have a vote. All in favor, please say aye. Aye. All opposed, please say no. Okay, the fine is reduced to $35,000.
We think we could take a big quick break before the next.
I think we could.
Please.
Let's take a 10-minute break. We'll take a break till 11:30.
Thank you.
Great, thank you. I know. This is fairly high pressure.
What'd you do there?
To read all these here?
I did. I'm really. I didn't see anything that really jumped out and required, yeah.
Oh, yeah. Agreed.
We're moving on to agenda item 8. Is Ms. Connors on the?
I've just asked her to join us.
Oh, great.
Yeah.
Ms. Connors, welcome.
Thank you.
You are very quiet right now. Is it possible to make her feed louder? Can she make her feed louder?
I think on her end.
Can you boost your volume at all?
My volume?
Oh, that's great.
Much better.
Okay. I don't know what I did, but great.
You just, you should take
Take all
credit
the
for
credit.
having solved the problem.
Take full credit.
Yeah. Mr. Wayne, you want to introduce us to the issue?
Sure, the commission voluntarily audits 20% of the candidates who are participating in the Maine election program. We're running for the legislature, and we use a contract auditing firm. Runyon Kirsten Willett won the contract for the 2022 audits, and Ms. Connors has been leading the way on that. And we appreciate all the efforts of the entire audit team. It's very painstaking work. Sometimes the candidates don't have all the paperwork, which causes delays and inefficiencies, and it's just not easy, and we really appreciate everything that they've done. The audits are, the 42 candidates are complete, and 2 of the audit reports were sent to you after the packet, and Ms. Connors has produced a draft version of a summary report, which is sort of a summary of her observations about the entire audit process. And I think she'd like to speak to that. And on that, we believe the staff believes no action is required by you on this.
Terrific. And thank you very much for your efforts and the efforts of your firm, Ms. Connors. So I think I read through these and they seem to be extremely well done, and you kind of brought together all the information that you could tease out of the candidates and presented a really useful report. So thank you.
Well, thank you. I will just kind of give a brief overview, since we did provide a draft of the summary report that sort of wraps up all of the reviews that we did. I apologize that I didn't get the summary report to you a little bit sooner. I was hoping to have it go out with the agenda, but we were in the process of wrapping up those very last 2 candidate reports. I'm not sure if you had a chance to look at the summary report too closely. If you look on page 3, we include a chart in there that talks about how many candidates were tested, how many had exceptions, how many had findings, and then there's kind of a brief summary of the different types of exceptions and findings that they had. So in total, to remind you, we did test 42 candidates for House and Senate both. There were 39 representatives and then 9. Did I get that backwards? That math does not work. Hold on just a second. Let me check. I'm trying to remember how many candidates we had of each. There were 9 Senate and 30, whatever that works out to be, 39?
30.
Thank you. Right. Of those 20 candidates, which was roughly half of the pool, had no exceptions or findings, which that means that 22 of the candidates did have either exceptions or findings. In total, there were 58 exceptions, which, to remind you, exceptions are things that we consider to be just minor errors and omissions. They don't necessarily, they're not violations of the law or anything like that, but they're still not following the guidance. So we include them in the reports just to point them out. They're mostly reporting errors. And then there were 4 findings in total, which were considered a little more serious. So as far as the trends go, I would say that the number one exception that we would see across the board would be obligations that were not reported as unpaid debts on the campaign finance report. Candidates still continue to report their expenditures based on when they were paid or when they cleared the bank statement, rather than when they first entered into that obligation, when they received an invoice or something along those lines. So in total, there were 10 candidates that had that as an exception. There were a total of 20 exceptions. And then the most common one after that would be a lack of supporting documentation. That would be for expenditures, it would be an invoice or a detailed receipt. For seed money contributions, we usually look to make sure that the candidate retained some sort of documentation as to who the donors were, whether it's a manual ledger or copies of the checks, something to show that they have something. They're supposed to be keeping records. And then after that, oh, sorry, go ahead.
I just wanted to note that I think we discussed with Mr. Wayne, after the last, audit report, that maybe we could do more in the educational arena to educate people about their obligation to report debts in a timely way. Have you given that any thought?
This is an issue that comes up every 2 years.
Right.
And, to be honest, I lost sight of that since your last meeting. I feel like we have examined and re-examined our guidance and previously had come to the conclusion that we're really doing our utmost.
Yeah.
In terms of the guidance, the written guidance, and mentioning it as often as we can. But I'll do it again because it can only help. And so.
I don't know.
Go ahead.
I mean, I'm just brainstorming here, but I wonder if even just putting a little star on the guidance and obligation saying this is the number one, exception, or however you want to phrase it, found in our annual audits. I encourage you to remember this or something,
So we're very open to that. We're not.
Yeah.
No. We have printed our revised guidebook so that's a complication, but we can.
Yeah.
I read a lot of paper copies, but electronic copies can always be revised.
Sure.
We don't expect you to sit down and hand modify.
Thank you. Yeah, I mean, we'll look at it again and then I'll talk it over, and there's some, I'm gonna talk over the whole issue with the staff.
That would be great, because it continues to be an issue, and it seems like the kind of thing that we can improve through some kind of additional education. I don't have anything more specific to recommend than that, but it seems like the kind of thing that people, they do just because they don't know, they don't understand the requirement.
I would have been accepted too.
Yeah, me too.
It's one thing when you make an order and you know exactly what the amount's gonna be, put that in. But oftentimes if you order something, you don't really know what the final cost is gonna be. And I guess the guidance is to put some estimated amount down or something. What happens if you don't know until you actually get the bill, what the cost was? We had an idea what it was, but a range.
We absolutely think we would recognize that practical obstacle to making the report. No matter what the guidance is, like we would not have an ironclad rule in any situation where it really mattered if they just couldn't come up with a number. But I do believe there are some situations in which we have advised, put down an estimate. So we'll look at that as well.
Great.
Great.
If I may,
Oh, please do.
actually, in our guidance this year, we updated the guidebooks, both the traditional and the MCEA, and we do have a piece in there. It's actually a little calendar that shows the candidate exactly what it means to report an obligation.
Oh, great.
So it is, and it's basically the guidebooks this year, we went with colored cardstock. So it is on one of those colored cardstock pages that shows them exactly, and it tells them debts and obligations, this is what you do.
Oh, great.
So
Terrific.
we did make an effort to change the guidance.
Super
Good.
We get copies of the guidebook.
Absolutely.
I think that'd be helpful.
Yeah,
There's an
sure.
understanding. I mean, not necessarily right now, but I mean, yeah, at some point. Absolutely.
Great. Thank you very much.
You're welcome.
Appreciate it. Ms. Connors, I'm sorry to interrupt you. I would encourage you to go on.
No, that's okay. We did include a couple of recommendations. As you mentioned in the past, we have recommended doing training. Another option would also be to build in some kind of flexibility as far as when the obligations are reported. Perhaps something like as long as they report the obligation within a month of when it's actually paid or something like that, or you could just have it for over a certain dollar threshold. Of course, you can exclude certain time periods that are more sensitive to reporting. But of course, you'd have to weigh that in conjunction with how important it is to get that information out. So.
True.
Tricky thing is that's what we're talking about, is whether people pay them, that's not the issue.
Right.
But people don't, and so
Right,
that,
right.
I appreciate the idea, but I do think this black and white view, I think this is easier to comply with, is
Yeah.
just getting the information out there, allowing estimates for costs and things.
Yep. Great, thank you.
You're welcome. The other issue that we noticed was the the lack of documentation, especially for seed money contributions. So I don't know if that's something you want to address as well, as far as how it's worded in the guidance. Some candidates, when we asked for supporting documentation for seed money contributions, they just sent us a copy of the seed money report. And we had to explain, no, we want to see what you actually kept for records, because they are supposed to be keeping records of the donors' names and addresses and so on. And a lot of times they're just not retaining that information, even though they are required to.
You think that was an issue of them having had the information and they didn't keep it, or never having had it in the first place?
I believe it's probably they had the information at the time that they prepared the report, and then they just didn't retain it.
That's what it sounded like in the report. Mr. Wayne, I think that's worth looking at as well. Yeah. Did you want to?
No, I just wanted to say, we did look, I had a conversation with Jen by email about this topic, and I did review the guidance in the guidebook that was given to the 2022 candidates did mention, but it is a very large guidebook, and, and it may escape some candidates' attention. And one of the feelings of the two candidate registrars exiting the 2022 campaign was that it's such a detailed guidebook and discourages people from actually reading it cover to cover. So in the copies of the guidebooks that we have here and that will be given to you, there's an intention to condense the information in the hopes that people will really digest all of it.
Yeah, it's a battle between sufficient detail and too much that will lose people's attention.
And is it clear in the guidebook that you have friendly staff that are willing to answer questions?
I think so. I mean, we always say, just call us.
Yep.
I mean, no, I actually put it in writing in the guidebook, but people get the word that we want to be known.
Ms. Connors? Feel free to go
Yes.
on if you have more.
That was pretty much it. I'm actually open to any questions or further discussion if you'd like.
Does anybody have any more questions?
I don't know if this is a fair question for you, because it's not like you have a grid you can compare, but given your background and what you do in general and how you think, how do you think this system is working? I mean, we can look at very specific parts of it and say, this has been a trend, that this could be better, but what's your sense and confidence of how this is working?
Well, I think overall the system is good. I think the guidance is pretty detailed, and most of the candidates do follow the guidance. As you can see from the report, most of what we found were just minor exceptions. I mean, we can talk about the number of candidates that didn't report their unpaid obligations, but at the end of the day, it's still just a minor reporting exception. It's not a violation. So I think overall the system works well. I think the issue that you're always going to have is that every time you have an election, you have a different pool of candidates, some of which, may not pay attention to the guidance or may be new. So you're always going to have that challenge. But I mean, the fact that we only had 4 findings out of all of the candidates that we selected, that's a, fairly small percentage of actual serious issues. So.
I agree. Thank you.
Sure.
Any questions or comments from anyone? Terrific. Well, thank you very much, Ms. Connors. We appreciate all of your work and we appreciate your appearance here today to lead us through it.
Great. Thank you.
Okay, we'll move on now to the executive session on the Alpine Initiatives LLC and Stop the Corridor issue. I would entertain a motion to go into executive session under the provisions of 1 M.R.S. section 405(6)E through F and section 1005 for the purpose of discussion and permitted deliberation upon investigative working papers of the commission in these matters made confidential by 21A M.R.S. section 1003 paragraph 3A. Is there such a motion? So moved. Is there a second?
Second.
Is there any discussion of the motion? Okay, I would like to do this as a roll call vote because we need to have 3 out of the 5 agree. So Commissioner Hastings?
Yes.
Commissioner Leclerc?
Yes.
Commissioner Marble?
Yes.
Commissioner Newman?
Yes.
And I will vote yes as well. So we have a 5-0 vote to go into executive session. So we will please clear the meeting room and we'll enter executive session. Thank you.
as they are now.
Save the signature, keep them going. Right now. We say something about reach something you need.
Okay, welcome back, everybody. We're back in public session. And we're considering the matter of Alpine Initiatives and Clean Energy for Maine, doing business as Stop the Corridor. I'd like to make a motion to accept and approve the consent agreements that were negotiated between the commission and the respondents, and to for the commission to authorize me to sign on behalf of the commission. Is there a second?
Second.
Is there any discussion? Okay, hearing none. I think we'd like to have a roll call vote. So Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marble,
Yes.
Commissioner Newman,
Yes.
and I'll vote yes as well. Very good. So I think if you guys can get signatures post haste, that would be great.
We'll get you copies. We have copies for you.
I think what we can do, or I know what we can do.
Excellent.
We don't have the signers in the building or locally accessible. We can get them signed today.
Yep.
And if you would like, we could provide scanned copies.
Yep.
And we will overnight the originals today.
Does that work?
That's fine, and I assume you would agree that once your folks sign it and the chair signs it, that the final agreement is done and we can go ahead and publish it. Once, in other words, we don't need, you would agree that we don't need to have the overnighted copy, because if both sides have signed it and exchange scanned copies, that's
So you're saying you want to publish it today?
today, right? If you sign, if we can get it signed by both sides today.
I guess I don't have a good basis to object to that. We prefer that you wait for the original, but
Well, so you don't object to not waiting for the original?
well, my preference would be that you wait till you receive the original.
I think we'd like to not wait until we receive the original.
And the decision is yours, Commissioners.
Okay.
You've heard my position.
Okay, terrific. Mr. Terrison, anything to add?
I have nothing to add.
Okay, terrific. Thank you all.
Thank you.
All. We have another matter to discuss in executive session, so I move that we go into executive session pursuant to Title I, Sections 405(6)(e) and Section 1005 in order to consult with the Commission Counsel concerning contemplated litigation against the Commission. Is there a second?
Second.
Is there any discussion? Okay, since this is a recorded vote, I would like to do it by roll call. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marble,
Yes.
Commissioner Newman.
Yes.
I'll also vote yes. So we are in executive session. Again.
Right,
Okay.
okay.
We have to.
Are we all set? Okay, we have just concluded the executive session to discuss a potential litigation matter. And that concludes our business for the day. Is there a motion to adjourn?
I move to adjourn.
Is there a second?
Second.
That motion is not debatable, so we'll move right to a vote. All in favor, please say aye.
Aye.
All opposed, please say no. It's unanimous. We're adjourned until next month.
So no, till January.
Oh, till January, that's right.
Now we don't have any.
Bye.
Safe travel.
Yes, you're right.